Power does what it wants. Power does what it wants. Power does what it wants.
Hey guys, Rogue Nation here with you today. We're going to be talking about a case, Price V Garland. It's from the DC Court of Appeals, Federal District Court, Court of Appeals. I'll include the link to the case in the description so you folks can read along if you like. Read it at your own leisure, whatever have you not. We're going to be starting on page 11 under the form analysis part. Now this is an important case because it fleshes out common sense, I guess you could say. And we'll get into why it's common sense that it's fleshing out. But I'm going to read some of the case here for you, and we'll go over the benefits to us, okay? Now this word right here, I have no idea how to pronounce. So, but we're going to start right here. And it says, because a filmmaker does not seek to communicate with others at the location in which he or she films, the filmmaker does not use the location as a forum. Therefore, the United States argues the district court's forum analysis was misplaced. Price counters that the district judge had it right. There is no basis to distinguish between filmmaking and other activities protected by the First Amendment. We think the government is correct. Based upon the historical underpinnings of forum analysis, the evolution of this analytical framework, and the cases in which the Supreme Court has applied it, we are convinced that it would be a category error to apply the speech protective rules of a public forum to regulation of an activity that involves merely a non-communicative step in the production of speech. Although this activity warrants solicitude under the First Amendment, that solicitude does not come from the speech protective rules of a public forum. In reaching this conclusion, we are buoyed by the Supreme Court's warning against extending the public forum doctrine in a mechanical way to contexts that meaningfully differ from those in which the doctrine has traditionally been applied. Okay, and we'll go over that. If they don't go over that, we'll go over that. We begin by examining the history of forum analysis and how the Supreme Court has described and justified it. Modern forum analysis come to fruition in the 1983 case of Perry Education Association versus Perry Local Educators Association, but its seeds have been planted decades earlier. Although the earlier cases did not present a fully developed forum doctrine, they are widely cited for their descriptions of the types of government-controlled property that are subject to special rules under the First Amendment. In Hague v. CIO, for instance, the court had stated, and you guys can read that, but what's important here is the words right here. For purposes of assembly, communicating thoughts between citizens, and discussing public questions. Okay? Assembly, communicate, discussing, speech, protest. Okay? Similarly, in Schneider v. State of New Jersey, Town of Irvington, the court had said that the streets were natural and proper places for the dissemination of information and opinion. Okay? Dissemination of information and opinion. Okay, again here in Cox v. State of New Hampshire, the right of assembly and the opportunities for the communication of thought and the discussion of public questions immemorially associated with resort to public places. Okay? And this goes back to even before, journalists and news was even a thing. Back in the day, they had what was known as the town crier. So, before newspapers and all that stuff, you had the town crier. And basically, the town crier was your news guy, right? And he would gather up all the information, and then he would go and he would stand on a corner, and he would, yell and tell people about this information. And that's what the town crier was. He was the local 6 o'clock news, right? So traditionally, the streets have always been a place where people would gather. They would discuss issues of the day. They would get their news from the town crier. So all that's, again, logical. In the 1970s, the court began using the term public forum to denote government-controlled property on which the government would have to tread far more lightly in regulating speech. Okay? Southeast Promotions versus Conrad, describing municipal theaters as public forums for and dedicated to expressive activities. Greer versus Spock. Gonna go on. Devoted to assembly and debate. The rights of the state to limit expressive activity. Two related commonalities run through the cases from Hague to Perry. The types of activities associated with public forums and the proffered justification for affording special protection to those activities in a public forum. As for the types of activities, these cases are concerned with assembly, the exchange of ideals to and among citizens, the discussion of public issues, the dissemination of information and opinion, and debate, all of which are communicative activities. Okay, and it doesn't matter what public forum doctrine case you pick. It can be Adderley, it can be Tinker, it could be Hague, it could be Kokenda, it could be Davis, it could be Brown. Any of these cases deal with only communicative activity. Every single one of them. It goes on to say that it should come as no surprise, therefore, that the court in Perry described the rule for a traditional public forum as follows. In these quintessential public forums, the government may not prohibit all communicative activity. The emphasis on communicative activities makes perfect sense considering the second commonality in the foundational cases, basing the justification for heightened protection of communicative activities in traditional public forums on their having immemorially been held in trust for that activity, and on participation in that activity being a privilege the public has enjoyed time out of mind. As explained by the most eloquent Professor Harry Calvin, Jr., this long-standing use of public forums provides the public with an easement on this type of property. It follows, as the Supreme Court has demonstrated, that to determine whether the highly speech-protective rules of a public forum apply to a given property, the question for a court is whether there is a traditional right of access. Comparable, it follows, as the Supreme Court has demonstrated, that to determine whether the highly speech-protective rules of a public forum apply to a given property, the question for a court is whether there is a traditional right of access comparable to that recognized for public streets and parks. Unsurprisingly, every single Supreme Court case from Perry onward in which the application of forum analysis was at issue involved communicative activity. See Perry, interschool mail system, taxpayers for Vincent, lampposts used to hang signs. Cornelius, access to government created charity drive conducted in federal workplaces during work hours. Forbes, debate among political candidates broadcast on public television stations. This buttresses our conclusion that forum analysis applies only to communicative activities, not to activities that, even if generally protected by the First Amendment, are not communicative. Though protected as speech under the First Amendment, filmmaking, like typing script, is not itself a communicative activity. It is merely a step in the creation of speech that will be communicated at some other time, usually in some other location. Creation of speech is not the type of activity for which streets and parks have been used time out of mind, and therefore it cannot be said that they have immorally been held in trust for such activity. There is no historical right of access to government property in order to create speech. Okay? And what they're saying there is that you don't have the right to government property in order to create speech. Okay? Which is absolutely true. Okay? That doesn't mean that you don't have the same right of access as every other citizen to that government property. Okay? Because as the court stated, once the government opens its doors for some citizens, it opens its doors for all citizens. Okay? That's a right of access. But you don't have a right of access to go into City Hall and to protest, which is creating speech. You don't have the right to go into City Hall and start yelling your sermon, okay, because that's creating speech, okay? But you do have the right to go in City Hall, and while you're waiting in line to pay your bill, or, talk to the mayor, while you're sitting there in the lobby waiting for the mayor to get done with his meeting and talk to you, you do have the right to write your sermon down in a notebook while you're waiting, okay? Because you're not creating speech right there. That's a part of, but it is not the expressive, communicative part of your sermon, right? The cases Price cites do not establish a general right to create recordings in public places. Save for one, those cases deal with the filming of a public official, usually a police officer, performing public duties on public property. Okay, so we're going to stop right there and we're going to focus on something. Here the court is acknowledging, okay, that a police officer is a public official. Okay? And what the courts know to be true and what we know to be true is if you're taking tax dollars to do a job for the government, you're a public official. Okay? You're not an elected public official, but you're still a public official. Okay? And then it gives a whole list of cases that basically say that, that's what the cases he cited were about. Filming a public official performing public duties on public property implicates unique First Amendment interests. Gathering information about about government officials in a form that can readily be disseminated to others serves a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. Glick, quoting Mills v. Alabama. It should come as no surprise, therefore, that these cases do not speak of a sweeping right to record in public, but of a narrower right to gather information about what public officials do on public property. We understand these cases as standing for the proposition that it is unreasonable to issue a blanket prohibition against the recording of a public official performing public duties on public property, so long as the recording does not interfere with the performance of the official's duties. Okay, now here's what I'm going to come into with that this case fleshes out common sense, right? Because in Smith v. Cumming, they said, we have the right to film government officials, public officials, in the course of their duties on public property, specifically matters of public interest, okay? The way the trolls and even some of these lawyers would have you believe is that the 11th Circuit Court of Appeals are idiots, okay? And that the 11th Circuit thinks that a public official walking from his car inside the building is his official public duties, okay? And that's not the case. Obviously, they said those specific words because they realized that public areas were allowed to record public officials conducting their public duties, right? There is no public duty of walking from your car into the building, okay? Which a lot of these guys would have you believe. Oh, you can't record, you can only record from outside the building. Okay. Basically, they're saying the 11th Circuit Court of Appeals are idiots that think that public duties consist of walking from their car to the building. Okay? We know better. Public officials' public duties are done in their offices, right? And if there's a publicly accessible area, lobby in that office, we're allowed to go there and we're allowed to record them. It's common sense. Okay? Such peaceful recording of the performance of a public duty in a public space is not reasonably subject to limitation. Okay? Now, with the public forum analysis, in the non-public forum, okay, which is the strictest they got, the restriction only has to be reasonable. Okay? And here, in the Price v. Garland case, it says, we'll read it again. We understand these cases as standing for the proposition that it is unreasonable to issue a blanket prohibition against the recording of a public official performing public duties. Unreasonable. Okay? This helps explain why these cases make no effort to determine whether the location of the recording is a public forum, because prohibiting the recording of a public official performing a public duty on public property is unreasonable. The specific nature of the public property is irrelevant. Okay? And maybe you guys have heard me sometimes or seen me debate with some trolls or argue with some trolls, and I tell them, I say, you can call it whatever you want. You can call it the non-public forum of the universe that no one is ever allowed to enter, so help you God. And none of that matters. You can call it limited public forum. You can call it a non-public forum. You can call it designated public forum. You can call it traditional public forum. You can call it whatever form you want. You can call it the non-public Darth Vader versus the Jedi Sith Mastermind Cut Down Yoda forum. Okay? You can call it whatever you want. It's irrelevant. Okay? It's irrelevant. Of the cases cited by Price, the only one that reaches beyond the recording of a public official on public property is Ness v. City of Bloomington. The court in that case concluded that a city ordinance banning the video recording of a child without the consent of the child's guardian was unconstitutional as applied to a person who wished to record alleged violations of a permit issued to a youth center by the city. As the court noted, however, the plaintiff's video recordings were of matters of public controversy for dissemination to the public, which the court likened to news gathering. Okay? Even that case, therefore, does not suggest a general right to record on public property. Although the Ness court proceeded to apply traditional forum analysis in concluding that the ordinance was unconstitutional, its analysis does not resolve the key question here. After noting that video recording is speech, the court merely assumed forum analysis should apply. It did not grapple with the differences between communicative activity and video recordings. As we have explained, extending traditional forum analysis in this manner ignores the analytical underpinnings of forum analysis. Okay, now we're going to stop here, and we're going to get into the rest on part 2.